Okay, we are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Master's Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. So good morning. We'll be conducting our first case on the Zoom platform. The matter is John Doe, number 338527 versus the Sex Offender Registry Board. My name is Judge Desmond. Your panel is comprised of also Justice Hand and Justice Brennan. As you know, it's 15 minutes per side with no rebuttal. Bear with me 1 second. And you both being seasoned practitioners here on the appeals court and on Zoom, I'll let you take it away, Mr. Attorney Faulkner.
Good morning. May it please the court. This is a case where SORB has classified a young man with an intellectual disability 8 years after the alleged offense. The guilty finding didn't enter until 5 years after the offense because the young man was deemed not competent to stand trial for a period of over 5 years.
So Attorney Faulkner, just for starters, let me ask two quick questions. One is, are you looking to reverse the level 2 classification, or are you strictly asking that the matter be remanded for additional findings?
Well, I suppose in the first instance, I'm looking for it to be reversed, and in the alternative, I'm looking for it to be remanded for additional findings.
Okay.
And
in your analysis, you don't quarrel with the factors that were cited by the hearing examiner, do you?
I don't necessarily quarrel with the factors that are cited, although I think the issue here is that the factors don't capture both the unique circumstances of this individual, and they do not capture the evidence in this case. In the SORB's brief, it referred to the fact that the SORB considers mental illness, but we're not dealing with mental illness. Although this individual does have some aspects of mental illness, the primary concern that differentiates Mr. Doe in this case from other people that appear before the SORB is an intellectual disability. That is not in and of itself a mental illness. It's something different. So we have, I'm sorry.
Go ahead. Finish your answer. I didn't mean to interrupt you.
I was just going to say that we have an individual here, for instance, who reads, he's now 28 years old, he reads on a 2nd grade level. So we're talking about somebody who's, although he is an adult, has the intellectual capabilities of essentially a young elementary school student.
So Attorney Faulkner, could I ask this, leaving the juvenile element out of it for a minute and focusing on the intellectual disability, what is the authoritative, what's the authority in this case that the hearing examiner should have looked to say that the intellectual disability was a factor for consideration here? How was that brought to his attention?
Well, interesting. I guess it's brought to his attention by a combination of the testimony and the fact that the case law makes clear that when we're looking at somebody who is not encompassed by the regulations, that those are circumstances that have to be taken into consideration. There's the appeals court case from 2012 that deals with a child. Since then, SORB has updated its regulations. There's the Supreme Judicial Court case involving age. There's since been updated regulations, but there are none of the SORB's regulations whatsoever deal with the intellectual disability. And it's clear from the testimony of Dr. Chirac and the fact that SORB authorized funds for that evaluation that the intellectual disability is not a circumstance that is accounted for in any way in SORB's regulations.
Oh, can I ask you a question, please? Oh, I'm sorry, go ahead, Judge.
Sorry, if I can just finish this. My question there is, I saw in the expert's testimony the reference to the fact that Mr. Doe had an intellectual disability. I understand that. The question about how that played into the risk assessment is the part I'm not clearly understanding, where the doctor's testimony addressed the fact that the assessment tools, which I take to be the actuarial tools, were not normed to Mr. Doe's particular intellectual circumstances. But as to the regulatory factors, I don't see that. Can you explain that to me a little bit?
Well, yes. So for instance, if I can have just a moment. SORB, for instance, cites to factor 35. So factor 35 is that the board shall consider evaluative reports, empirically risk assessment instruments, or testimony from a licensed mental health professional that discusses psychological and psychiatric issues, including major mental illness, as they refer to the offender's risk of reoffense. And so SORB specifically directs its regulation towards mental illness and psychological and psychiatric issues, but does not direct it towards the intellectual disability. And the intellectual disability plays in throughout Dr. Chirac's testimony. So even though he says that various risk assessments in and of themselves cannot stand on their own because they haven't been normed to that, he's an expert that has spent 17 years as the director of a home that treats intellectually disabled sex offenders. So he's got a wealth of experience in that area. So he's not somebody who has simply come to only rely on these assessments. He's relying on these assessments and his experience in treating people in the very circumstances that Doe finds himself. And in combination, he relies extensively on the historical record. So the hearing examiner, for instance, criticizes Dr. Chirac's testimony because he says, well, it's entirely reliant on self-reporting. And to some extent, the actuarial tools do involve the interview between Dr. Chirac and Mr. Doe. But Dr. Chirac goes far beyond that. He's read the historical documents. He's interviewed with Marissa Trambowitz, who is the director of the group home where Doe is living. He has interviewed with the psychologist that is treating Doe. And although I'm suggesting that there's a distinction between the psychological issues and the intellectual disability, he has interviewed both of those people. So the hearing examiner doesn't exactly get it right when the hearing examiner says that Dr. Chirac his assessment is based on simply self-reporting. That's not accurate. There's a wealth of information that's relied upon.
Can I dial you back one moment to where Justice Hand was? So do I understand your position to be that that the examiner theoretically may go outside the regulatory structure and the factors that are there? And if so, how do we then avoid, what's the guidance, and how do we avoid what presumably the regulatory factors are there for, which is to limit, if not eliminate, arbitrary decisions or arbitrary bases?
So first, I believe that the expert absolutely can go outside. Obviously, he has to take into account the SORB regulatory factors, but he's not limited to relying on those factors. He is an expert who treats these kinds of people. He's entitled to rely upon his expertise. He must take into account the factors. So that's the first response. The second part of your question as to the purpose of the regulations, the purpose of the regulations is not necessarily I think what Your Honor has suggested, the purpose of the regulations is to make sure that the SORB is accurately assessing the risk, and the regulations are supposed to be updated and taking into account all of the most recent information. And that's why, in response to a number of appellate decisions, those regulations have been updated. But those regulations have never been updated to deal in any way with intellectual disability. And that's the problem here.
Do you agree that the the expert, Dr. Chirac, failed to consider additional regulatory factors that the board was required to consider in reaching his opinion that he was level 1?
So I'm not sure that I agree with that. And that's something that the hearing examiner found. He said that, he criticized Dr. Chirac for not considering certain regulatory factors. One of those regulatory factors that he criticized Dr. Chirac for not considering was, I believe it's factor 34, which is simply materials submitted by the sex offender. And certainly that is something that Dr. Chirac did consider. There were 2 or 3 other factors that the hearing examiner criticized Dr. Chirac for not considering. But if you go back and read the transcript, there's no indication one way or the other that those that those factors were considered or rejected. He simply wasn't asked about those factors. So
isn't that the issue though? Isn't that exactly the point? That we have no way of knowing whether he did consider those factors as is required and how they weighed into his level 1 finding.
So number one, I don't believe that the expert's not required to simply go through a checklist. There's 35 factors and say, I considered this factor, I didn't consider this factor, I considered this factor, I didn't consider this factor. And that's the way it's treated by the hearing examiner. Certainly, to the extent that there are applicable factors, it would be important, I think, that the witness has at least thought about those factors, but I don't think it's a basis to reject his testimony in total simply because there was no testimony one way or the other about the impact of those factors. He wasn't cross-examined. Are you
suggesting that Are you suggesting that Dr. Chirac's testimony was rejected in total? Is that what I hear you say?
Well, his opinion essentially was rejected. So some of the factual information.
I thought he gave his opinion limited weight.
So that's I don't think is a fair way of reading his opinion, and by his I mean the hearing examiner. So the hearing examiner did say that he gave it weight commensurate with its application to the factors or something along those lines. But then there's absolutely no indication of what that weight was or which factors he considered to have been appropriately applied. And I'll see if I can just quickly find that language. But it was not, he really didn't explain what that weight was. So it's one thing to say I'm giving it some kind of weight based on something, but then he doesn't in any way explain what that weight is and what it was based on. Let me see. I apologize. Okay, so where I'm looking at, and this is in the record appendix at 296 to 297, the tests and tools by Dr. Chirac address some, but not all of the factors. I therefore give the tests and tools used by Dr. Chirac some weight to the extent that each was correctly applied to the facts, and in so doing, only to the extent that each may be seen as a general indicator of risk of reoffense. So he doesn't in any way at that point say which ones have been correctly applied to the facts in what the weight is that he's giving to them. So I do think in terms of the opinion, Dr. Chirac's opinion is what is rejected by the hearing examiner. So I guess it's not accurate to say all of his testimony has been rejected. That's not true, but the
Doesn't he
ultimate
say-
opinion.
Just say in the next line, I largely agree with Dr. Chirac's testimony regarding the application of the SORB factors, but then he finds that there were other factors that were applicable. What's wrong with that?
So
Very next
again,
line, after you,
right. So what he doesn't, though, is say, although he says that he finds other factors were applicable, he doesn't in any way find whether Dr. Chirac has considered those factors and whether they are accurate. The other part of it is, importantly, he's limiting Dr. Chirac's testimony, therefore, to the SORB factors and nothing more, when exactly the purpose of Dr. Chirac's testimony is to explain, in the circumstances of this intellectually disabled young man, what it is that is different from the SORB factors and why the SORB factors aren't sufficient in and of themselves to classify this case. If the SORB factors were sufficient in and of themselves, there would be no need for expert testimony, and there'd be no purpose for the testimony. I see that my time is expiring, so unless there are other questions.
I think we do have another question.
I have one. Attorney Faulkner, can you just tell me your reference to disability discrimination in your brief, pages 45, 46, is that meant as a point of emphasis, or are you asking us to consider that as appellate argument? As a separate claim, I suppose.
I'm not sure that it's a separate claim. I think it's a point of emphasis, and when we're considering the treatment that the testimony is given and the treatment that Doe is given by the SORB, I think the argument is essentially that in the entire scheme, that the SORB isn't adequately giving a reasonable accommodation to the disability.
Thank you.
And
Thank you.
you also agree that Dr. Chirac also kind of formed his opinion based on some of the services that are presently in place for Doe?
Correct.
All right, I think we got it. Thank you very much. We'll now turn to Attorney Chanel.
Thank you, David Chennai for the board, if it pleases the court. I want to start off by saying right off the beginning that, and I'm not saying the court should do this, send the case back, but if it is remanded in any way, I would recommend at this point that a new hearing be ordered, only because last week on April 9th, this individual is eligible for a reclassification upon the ending of this case. So it would be duplicitous to send it back for new findings and then go through the process again of going to the Superior Court and to this court based on a 2019 classification. But the board's main position is that this case shouldn't be remanded in any way because the hearing examiner made the appropriate findings of fact and the evidence supported the decision. I think the big problem with the expert's opinion in this really was that it was based on the status quo. And the status quo of this individual was he was in a guardianship. And there's no guarantee that guardianship would keep him in the same services in the future. And it's in one of those kind of gray areas. If you were incarcerated and released into the community, the board would obviously be informed. In this situation, if this individual were allowed to, if they stopped the guardianship and he was allowed into the community, the board wouldn't necessarily be aware of that. And I think that puts an added dimension to this case. It's unfortunate this individual has these issues, but I don't see that his intellectual disabilities and his mental health issues in any way reduce his risk. I think the hearing examiner took into account his current situation by giving him credit for his current stability based on the program he's in, his support network that he has. And I think those are the factors that dropped his high risk to a level 2. I think, based on the brief that I filed, I think I cover these issues well. Unless there are specific questions, I'd be more than happy to rest on my brief.
There's no indication, Attorney Chennai, that the guardianship was going to end at any particular time, and certainly not imminently, at least in the record. Is that correct?
Correct. But that's the problem with these kind of cases. it's not like if it does end, that anybody's required to notify the board that this individual has gone into the community. Theoretically, this individual would have to keep the board on notice of where he's residing. But again, the board wouldn't necessarily know exactly when he goes into the community. And it kind of reminds you of like, it's correlates to the desire of the board, or the statute requirement that the board make sure the individual is classified before they leave incarceration whenever possible, so that an individual who poses a risk doesn't go into the community and have that lapse before the board can classify him. And that's, no, though not quite the same. It's the same type of issue in this case. This individual could go into the community and be in the community for a period of time before the board is aware that he is in the community. And I think that changes the dynamic of this case a little bit, at least on that area, because the doctor really focused on the fact that as long as he's in the program he's in, his risk, according to the doctor, is low. But the doctor made it clear, if he leaves that program and doesn't keep up with his services, that risk could go up exponentially. And I think that's the issue here to grapple with, is that, sure, he has intellectual disabilities, but those intellectual disabilities don't lower his risk. They actually increase the risk, because it causes him to act in ways that, even during treatment, they discuss the aggressive ways that he acts when he's not properly supervised and properly in treatment. So I think that, again, that is an issue in this case, is that this individual, the board can't really judge when he would be released into the community.
I'm sorry, go ahead.
Sure, go ahead. I finished.
That's okay. Did I understand you correctly that he's got another hearing next week?
No. He's eligible for a reclassification hearing now. Every 3 years,
Okay.
an offender has a right to reclassification
Okay.
from their old classification, as long as they have no cases pending. So upon the decision of this court, he will be eligible to apply for a reclassification. All I'm saying is that if this court were inclined, which I'm not advocating you do, but if you were inclined to remand this matter, rather than go for additional facts, which would then start the Superior Court process again for an April 9th, 2019 decision, it probably would behoove, it would basically be better judicial economy to just have him have a new hearing and start from scratch, because again, he's going to have a right to a reclassification when this is done.
So he presently has two guardians now, is that right? His mom and an
Yes, his
attorney?
mom and his attorney, yes.
Okay. And if this, as of today, he denies the index offense, is that right?
Correct. I think I'm not, I haven't seen his records since the 2019, but of course we're basing this decision on the facts of 2019. At that time, he was telling the treatment providers that he was tricked into pleading guilty and only pled guilty so that he could go home, and that he didn't commit the offenses.
Got it. Check with my panel members. Any additional questions? All right, well, very well argued by both sides. We appreciate it. The matter stands submitted.
Thank you. And I'd like to thank the panel for allowing me to do this by Zoom today. I'm hoping I'll be up and around by next month to come into Boston personally.
We hope so too.
Thank you. Thank you, Your Honor.
Thanks.